Very good evening, everyone, and hope you're having a great day so far. Thank you for taking time this evening to join us on this May's installment of Money Hour webinar series. So today we are going to be talking about the topic of estate planning, right? And I think it's a topic that is we believe it's very important, and we wanted to also share because this topic of estate planning has come up recently in the news, right? And it's making its rounds. So thank you very much once again. For those who have not had your dinner, I hope you are having your dinner as you are listening in to this evening's webinar session. Hope you had a good dinner. For those of you who had, make yourselves comfortable, and I will try and make this next hour of sharing easy to take in as possible. And feel free to ask any questions that you may have in the chat box below. If you have any questions, we'll try to address them. But as always, just wanted to put out a quick disclaimer before we get started on today's session. It's going to be a lot of information that we are sharing, and these are all publicly available information, right? By no means does this constitute to any form of financial advice, nor is it any form of legal advice as well. So be very careful with that. But I would also like to give us the assurance that the topic of estate planning is really not that difficult and not that complicated. After today's session, hopefully all of us will be able to get deeper insights into this topic of estate planning, right? And particularly, I also want to just introduce who we are, Money Owl, right? For those of you who are new to us, right, you may or may not have heard of us before. Now, we are a financial advisor, and we are your financial advisor on a social mission, right? And we do not sell any products. And I welcome all of you to either follow us on our Instagram, follow us on our other social media, Facebook as well. Go on to our website, and we have plenty of resources available to help you in your own personal financial planning journey. So an example of how we do that is that we have curated what we call financial checklists, right? So depending on which stage of life you are at, right, we do have a few checklists that you can consider you can consider checking it out, and hopefully be able to improve your own personal financial situation. Now, I hope that at the end of today's session, I will also be able to motivate some of us to take some actions, right? And also, I would like to share that it is really not difficult for some of these actions to be taken as well, right? So that is a little bit about Money Owl, right? So we are a licensed financial advisor, and we are here to provide this education, right? And through the content that we share on both our social media and on our website. Now, a little bit about myself. My name is Albert, and I've been with Money Owl for coming 6.5 years, thereabouts, and I have more than 10 years of experience in this area, particularly as a certified financial planner and also an associate estate planning practitioner. So really, I think this is a topic that is quite of my interest, right? And I really do enjoy tending to some of these questions that some of you may have as well, right? So, but by having that associate estate planning practitioner, it simply means to say that I am a little bit more better informed than the average adult, right? By no means am I a probate lawyer, right? So just be very clear on that. But I do enjoy sharing my experience in this kind of settings as well. And hopefully I'll be able to make this topic a little bit more digestible for all of us today, and more importantly, help all of us take action on this area of planning, right? So there are going to be a couple of areas that we are going to cover this evening, and we will start off with understanding, what happens, right? What happens? Eventually, every one of us will pass away. Every one of us will die at some point. What are some of the problems? What are some of the issues that may arise when we pass away? And I would like to share, following that, right, the problems that intestacy brings about, right? Then the importance of writing a will. A lot of times we think of writing a will as a very complicated matter or very expensive exercise, but really it isn't, right? And I like to highlight what are some of these important points that we would like to take note of. Now, a will is a very important document. We all know that, but I also want to be very mindful that we'd like to all of us to remember that a will is not the magical tool, right? That it can take care of every single thing in your estate plan. There are certain assets that are not able to be included in your will, and we will discuss that together. And finally, we'll wrap up the today's topic on estate planning with a short sharing on another very important document, which is called the lasting power of attorney. Now, before we get started, I also want to just quickly bring up this news article. 2 weeks ago, right, our former president, Madam Halimah Yacob, was at an estate planning symposium, right, that was organized by the Silver Caregivers Cooperative, right? So this was on 18th of May, covered on 18th of May. The event was held a day earlier, 17th of May. Now, she shared that, it's important for seniors in particular, because we are going into an aging, super aged society in Singapore, right? But there are a lot of seniors specifically, right, who have not started on their estate planning matters. And we can see in the highlighted paragraph over here, right, conveying our last wishes, communicating to loved ones our preferences regarding funeral rites, especially when there are certain religious traditions that you need to follow, right? It's critical. And why is it critical? So that our loved ones have clarity over what they need to do, over over how things should be done as well. Now, in this article as well, and in Madam Halimah's sharing, she also talked a little bit about lasting power of attorney. I thought it was important to include that in our sharing today. Now, so what is estate planning? Now, it's a very big word. When I was doing the preparation for this talk, and I was just going around asking the interns that we have, younger crowd, what is estate planning? Now, typically, because of the word estate, and we live in housing estates in Singapore, we typically tend to relate it to something to do with housing. Nothing wrong with that. I think that is partly correct. But really, estate planning encompasses more than just our house. It also encompasses everything else that we own, our assets. What happens to our assets after we die? And there are a list of documents, right? There are a list of documents that we can make use of, including a will, including nominations, including how you own the assets as well. That depends, that will determine, right, how you can distribute some of these assets after death. Now, there's also an instrument called a trust as well, and we'll discuss that in detail later on this evening. Now, there is also another part of estate planning that is important, and it's when you are still alive. A lot of people do miss this out as well, and they think that estate planning is just after we die. After we die, we don't really have to do that much, right? Because generally, I think innately, people are generally just not that bothered, right? Because the mentality is today I'm no longer around. Then why should I be doing all these plans as well? But really, it's to provide a little bit more clarity for your loved ones, not for yourself, because you are no longer around. Now, on that same line of thought, right, today, if you have lost your mental capacity, you are unable to make decisions for yourself, what are the things that you need to do? There are some procedures, advanced care plan, some documents that you can consider as well, lasting power of attorney, advanced medical directive. Now, whatever I've mentioned over here, they are just tools and processes. Now, estate planning is not just about, splitting how much money your family should get, who should get what property. It's also about what you leave behind, right? It's also about communication of your personal beliefs, your own values, and how you would like to be remembered. So there's this part that also a lot of people tend to leave out, because you are more than what you own. People remember you for who you are, not how much money you own, right? So there is also another document. Now, this is not a legally binding document. It is called the Letter of Wishes. Essentially, it's as the name suggests, it is a letter where you state your wishes, right? So it's a very simple document that you can have. Just write it simply, plain English. Make sure that you put down your wishes in a very clear and easy to understand manner. And this is how you can communicate your beliefs, right? Your values, right? And how you wish to be cared, to be remembered, right? In the event that you are no longer around. Then why is it important? I think first and foremost to understand why is this process of planning important in the first place. So when we die, there is a funnel that channels all of our assets, including our personal assets, our life insurance, CPF money as well, right? Channels down to our beneficiaries. But you realize in this funnel, there's a little siphon. There's a little siphon where we need to be very mindful of certain leakages that could happen in our estate distribution process. Now, a lot of times we tend to oversimplify the whole process whereby we think that after we die, oh, my family, based on relationships, they will get certain things in a certain manner. The law provides for that. But we forget, there are certain leakages that are out of our control. Now, the first being estate duty, but I just want to also highlight, I just put this here, but today there is no estate duty in Singapore. Since 2008, we no longer have estate duty. Now, I don't suppose we have any case of deaths happening before 2008, and then we are talking about estate distribution today, which is a good 15, 20 years later, right? But in essence, deaths occurring after 2008, no more estate duty. But why is it important? Why have I put it here as the first consideration? Now, a lot of us, we have investments all over the world these days, right? And there are other countries where we may have certain assets that they may have estate duty. So it is important for us to be mindful. Today, if we have investments overseas, if we have property overseas, we have savings account overseas. Now, these days we go overseas to study, to work, and so on and so forth. So it's very important to take note of that estate duty bit, right? If you own assets in other countries that have estate duty. But in Singapore, no more estate duty, so we don't have to worry about that. Now, today, the second biggest leakage would come in the form of legal and probate costs. Now, why is there a cost in this? Now, for a very simple reason, today, imagine with me, somebody in your family passes away, right? Unfortunate event happens, somebody passes away, everybody is grieving. Now, everybody doesn't know what to do, assuming there was no plan in place, right? No wills, no nothing, no letter of wishes. So where do we get started? Where do we get started? We typically will go to the professional. The professional in this case would be a probate lawyer, right? Now, you will get a probate lawyer to give you advice on certain matters, how to go to court, what are the documents to submit, and so on and so forth. Now, we know that it is an expensive episode, right? Today, if we were to sit down at a probate lawyer, it can start costing in excess of few hundreds or few thousands of dollars even, right? So depending on the complexity of your estate, right, the legal probate cost could be more as well. Now, even if you have already done all your plans nicely, there is also another cost in what we call the probate cost, which is the fees that you need to pay to court, right? A lot of times people also forget that, we need to pay the people in the court as well, right? For them to provide us with the certain documents that are needed, namely your grant of probate or grant of administration. These are the letters that can allow the family members to go ahead and distribute your estate. So there is cost in there as well. Now, the third and the fourth point will be easier to understand. Now, today, if we die, we either die in the hospital or we die at home or somewhere in between. Now, today, if we were to die in the hospital, we are likely going to be incurring medical bills. And it is important for us to be very mindful that these medical bills are taken care of. Otherwise, it will fall to the responsibility of our loved ones as well. And also income tax, right? Today, if you are, you die a natural death at maybe, way past your retirement age in your 90s, maybe 100 years old or thereafter, likely you wouldn't have any income tax. Now, today, if unfortunately a sudden death occurs and you are still an active working adult, then there is likely going to be outstanding income tax. IRAs will then be entitled to claim that outstanding income tax that is payable for the previous year of assessment. Now, that also includes other creditors such as the banks whom you have loans with. It also includes HDB, one of the biggest creditors in Singapore, right? Because most of us, we own HDB flats. Most of us, we would likely have a loan from HDB, right? So those are the creditors that we're talking about. And finally, which is by no means going to be the least important, it is also as important as the rest, which is your funeral costs. And this really depends on your religious beliefs. Now, today, this can be a whole spectrum. Now, depending on whether or not your religious beliefs require certain rites and rituals, or does it require burial within a certain time period, as in the case of Muslims, for example, right? Burial is required to be done within 24 hours of death, according to the Sharia law. So typically, funeral costs for Muslims are generally lower, and typically for Chinese, right? We have these days different types of funerals. Today you can be a Buddhist or Taoist, but these days we sort of the rites and rituals sort of just overlap each other. We take the best practices of everywhere, and it can cost quite a big sum of money, right? In the regions of tens of thousands even, right? Depending on how elaborate the rites and rituals are. And these are important, right? Depending on your personal religious beliefs. Even today, if you tell me, oh no, Albert, I'm a free thinker. I don't think I need to go through all those rites. You still need to pay money to who? To the government, right? Because you will need some way and means to dispose of the body, be it going to the crematorium or having a burial site for that matter, or a sea burial, or at the Garden of Peace, right? If you wish to have that. So there's a whole list of expenses that we would like to minimize, and so that our beneficiaries can get the most out of whatever estate that we leave behind. We earn, we work so hard, right, in our lives to earn a good living. But if death happens, we can't take all this money away, all this property back, into the graves with us. So we want to leave it for our loved ones, but we want to maximize what our loved ones can get. And that brings me to the second part of this evening's sharing, which is on estate distribution. Now, today, really just two ways, right? Which is dying without a will, you die intestate. Dying with a will, you die testate, right? So today, if you have already written a will, in my audience today, if you have already written a will, you are the testator in your will, right? And today, if for those of us in my audience, we have not written a will, this is how our estate will be distributed. Now, today, if you are a non-Muslim, we follow the Intestate Succession Act. The Intestate Succession Act only applies for non-Muslims. Now today, if you happen to be a Muslim, there is another set of law that you will need to follow called the Sharia law, specifically the Faraid. Now, let me just very quickly go through this very big table, right, which essentially is what we call the Intestate Succession Act. And perhaps I'll take a pause for a minute or two just to let us have a look at this manner of distribution. This is the law that helps us decide whether or not, who gets what if we have not written a will. Now, I'm sure some of you are looking at this table and you're wondering, right? There's this interesting word that you see in the table, issue, right? What is issue? I always like to joke in my sharing, right? Today, if you have children, you have issues, right? If you do not have children, you do not have an issue. That's fine. But it's more than just your children. It's also your grandchildren, essentially your bloodline, right? Issues also include legally adopted children, right? So not just your bloodline, but also legally adopted children. Now, depending on how your family situation is, you could fall anywhere in and around this table, right? And it follows in order, right? So rule number one, rule number two, number three, number four, number five, number six, all the way down to the last rule, if none of these situations apply to you. Now, I just want to park this thought with all of you. Look at this and think of whether is it a fair way of distribution. Now, some of you may feel that, oh yeah, this looks pretty fair to me, 50% to one party and 50% to the other party. Yeah, looks pretty decent to me. This was how I intended to distribute anyway. Now, we'll come back and revisit this in a short while. Now, if I happen to have any Muslim in my audience, right, today we don't follow that, right? We will follow what we call the faraid. Now, typically for the faraid in Sharia law, the man will receive more in terms of the number of shares as compared to a woman beneficiary. Now, the reason, now I'm not an expert, neither am I Sharia compliant, but this is as much as I understand because it is by means of the teachings, right, that the males in the family are expected to take care of the family with the more resources that they are allocated. And there is a good reason why today, if you are a Muslim, you would like to write a will as well, because you may have certain beneficiaries who are outside of the faraid, right? So you may you may want to consider that as well. But there is no specific table that I can share because each of you would have a slightly different family makeup, right? Family situation. This is what I have from the Sharia court, which is the inheritance calculator. You put in your family makeup and the amount, the number of shares per loved one will be calculated accordingly for you. So that's a point to note for my Muslim audience. Now, let's discuss the Intestate Succession Act together. And I would like to share the example of my friends, Jack and Jill. Now, Jack and Jill, they are a young couple, a very successful young couple. They both each have $1 million assets. They worked very hard and they've made their mark in life. They just newly got married, right? And therefore they have not had any children yet. And they also have not written their wills, thinking that, oh, okay, they are still young, they have still got long time to go. They may feel that, it's not the first thing on their minds right now. Now, today, in their situation, if they were to pass away, right, both of them, they may leave behind their parents, right? So Jack has his dad and mom, Jill has her dad and mom. If they pass away today, this is the cutout that I have from the earlier table, right? Today, if they were to die, they would leave behind the spouse and parents, right? So the spouse and parents will then get a share, 50% to the spouse and 50% to the parents. Now, if I were to ask the question to all of you in my audience, maybe some of you already know this, but some of you may find it surprising to know that today, the parents are not going to get $500,000 each, as you see on the screen, right? Because today, you realize if I were to refer to this rule, the parents are still around, the spouse is around. That means today, if they die together, right? If they die together, somebody has to die first. So who dies first? Right? In order for us to follow this rule, if both of them were to die away together in an unlikely event, maybe they went on a honeymoon, right? And plane crash, and both of them died together. No children, no wills. But somebody has to die first in order for the courts to distribute their assets. Anyone knows in my audience who should die first or who is deemed to have died first? Kathy says the younger one. Yes, the older one. Right, exactly so, right? So today, thank you very much, Jeanette. Right, today, let me just put in some age for reference. And let's say if Jack was the older one, right, then he is deemed to have died first. The younger one is assumed to have survived, right? But eventually, both of them have died. So in this case, Jack has died first, right? Therefore, half of his assets will be split to Jill, right? Who was assumed to have survived him. Half of his assets will then flow to his dad and his mom, leaving his dad and his mom with just $250,000 each. And Jill's parents will get 750,000 because she has gotten that 500,000 plus her own 1 million in assets, right? And eventually she has also died following the death of her husband, right? So 750,000 each. Not exactly a fair way of distribution, I believe. We can all agree on that. Now, obviously, today, if Jill was the older one between the couple, then Jill is assumed to have passed away first, right? So this is what we call the common disaster clause, right? The big legal term is Comorian test. Don't really have to bother too much with this. It was just an interesting example that I wanted to share. It's very rare that this happens, but it does happen. If there is a possibility of it happening, we would like to have clarity, right? In the event that both of these husband and wife, if they pass away together, especially if there are children involved, and especially if the children are below the age of 21, they are still not adults yet, right? That's very important for them to consider writing a will. And that brings me to this next part, right? Which is why is it important, right? And you have seen, right? It may not go according to our wishes. The law does not have eyes, right? The law does not have eyes, and it doesn't consider emotional aspects of distribution. Not just the fairness in distribution, but also the cost. Now, bear in mind, today when I'm talking about the cost of distribution, I'm not just talking about the monetary cost. Monetary cost, easy, right? We can use money. I always like to say, today, if you can use money to solve the problem, it's no longer a problem. But today, when money cannot solve the problem, then it becomes a major issue. What do I mean? Time cost is also a very big concern, right? Now, today, without a will, without a proper estate plan in place, it will take your family a long time to get that money because there's so much more paperwork they need to do. They need to provide, this proof, that proof. The courts will need to go in and out, things like that. Go to the law firm, things like that, right? Time cost. Often we forget that time is cost as well, right? Now, I would like to just share a very easy to understand analogy with all my audience, all of you today, which is that, today, if we have done a proper estate plan in place, if we have put in place a proper estate plan, done your wills, done your nominations, things like that, in the event of a death, money finds your family. Today, if we have not done a plan, we have not had any wills in place, no nominations, nothing, your family will need to find your money. Now, I hope that makes a bit of sense to some of you, right? And I believe most of us, we would like to opt for the first option, right? Today, in the event of my death, I hope that money goes and find my family, not my family goes and find my money, not the other way around, right? And that's how we can reduce the time cost in estate distribution. So bear in mind, that's very important. And I mentioned earlier, today, some of you in my audience could be parents to minor children. Now, what is a minor? Minor is someone who is under the age of 21, right? Still have not attained adulthood yet, right? Unable to make decisions for himself or herself. Now, today, if you do not appoint someone to take care of your children, the courts will appoint. And the court's decision, again, I say, right? The law does not have eyes. The courts base it on logic, not based on emotion. So today, the courts may order for maybe your sibling or maybe your parents and they may not be in the best position to take care of your children, right? Maybe it could be an estranged sibling. You have not talked to him or her for the longest time. Maybe your sibling could have moved overseas, for the longest time. You have not seen your sibling for 10, 20 years, and then the court orders your sibling to take care of your children, minor children. Parents, right? Maybe your parents are in their 80s, 90s, right? They have a hard time looking after themselves. How would they take care of your minor children as well? So those are what we call guardians, right? So guardians are who you appoint to take care of the well-being of your minor children. Now, trustees are essentially the gatekeeper of the money, right? For someone who is under the age of 21, beneficiaries under the age of 21, their share of money will be taken care of by the trustee. Now, the trustee, executor, guardian, they may be the same people, but they hold different roles. Just like how we have different portfolios at work, right? Same thing. It can be the same person, but by law, you are required to perform different duties. Now, the fourth point is important as well. This concept of surety bond, which is required by the courts, right? Because today, if you have not written a will, the courts will require now how big your assets are. Let's take the example of Jack, right? If he has not written a will, his family will need to find totally unrelated person with personal assets of each 500,000. So two surety bonds are required, right? $500,000 each, adding up to the same amount of total assets that Jack has left behind to act as a surety bond, right? In case the person who nominates himself as an administrator goes to court, right, to try and initiate this whole process, the courts are afraid that this administrator may run away with that $1 million, right? So these two surety bonds, right, are supposed to provide that guarantee. So who are you going to find? If your assets are $1 million you leave behind, your loved ones will have a hard time finding someone to want to put their name on the line for you, right? And using their own personal assets as a bond to put to court, right? So very, very challenging. And yeah, I think that is enough said on why is it important. So finally, I just want to also wrap up that this concept of marriage, right? Today, if you go through a marriage, there is a new family unit formed. And because there is a new family unit formed, all previous dispositions, your wills, nominations, everything is revoked, right? Because there's a new family unit formed. Now, today, if there is a divorce, your previous will does not get revoked automatically, neither does your nominations. And you will see this point being repeated in my next few slides as well, for a very good reason. Now, today, a married couple may have children, right? And the married couple may decide they want to split up. But the children are still minors. They still depend on their parents, even though the parents have split up. Now, if you have made a will previously to take care of your children, the courts will assume that you still want to provide for them. And that is why there is no auto revoke for a divorce case. And that is why it's also important today. If unfortunately, there's a case of divorce that happens in the family, please do review your wills and nominations. Now, I mentioned, right, there is a part that there are certain areas or certain assets that the wills cannot cover. And what are they? Namely, jointly held assets and nominations, right? Assets that you can do nominations, your CPF, your insurance policies where you have made a trust nomination, right? These are assets that cannot be included in the will. Or in other words, the will cannot override these assets. Now, we'll talk about this together in detail. Now, just want to touch on property first. Why? Because property is probably the biggest asset that all of us have, right, in our working lives. So, the natural question everybody will always ask, right? Today, if I die, what happens to my HDB? What happens to my condo? What happens to my property? Now, today, if you are the sole owner to your property, simple. Put it into the will, right? And you can bequest it however you want. Now, just bear in mind that today, if you do not put it in the will, if you just leave it to the Intestate Succession Act, or you just use a simple will, right? So a simple will basically assumes at death, the property is sold and distributed in cash, right? So it may not be ideal situation for you as well. So you might want to put it clearly stated out in a clause that this property you want it to be left for beneficiary A, B, C, for a certain period of years, and so on and so forth. That one, you will need to approach a professional will writer or a probate lawyer for that purpose. Now, most of us, on the other hand, we tend to have property via a joint ownership. Now, joint ownership can happen in the form of either a tenancy in common or a joint tenancy. Now, today, if you own a joint tenancy property, you are assumed to have full ownership of the whole property together with the co-owner, right? So a rule of survivorship will apply. So in the event of the death of either of the co-owners, the surviving co-owner owns the property fully, also takes over the outstanding loans accordingly, right? So that is joint tenancy. Now, most of us, if we get our first property, and if it's a HDB, most likely it's going to be a joint tenancy. Now, for whatever reason, if you intend to change it to a tenancy in common arrangement, that means you own distinct shares in your property. Now, usually tenancy in common occurs when you are talking about investment property, for example, right? So investment property, right? Usually you have, a few shareholders. Maybe you want to buy an investment property with your siblings, with your friends, and so on and so forth. Each person owns a distinct share. You are able to will your share of the property away in the event of your death. Now, therein lies a potential issue whereby today in the death of one of the co-owners of a property in tenancy or in common, now the surviving co-owners may not want to sell off the property, right? They may still want to hold on to their share, and therein lies the need for the use of insurance, right? So we do have certain ways that we can manage this with buy-sell agreement, and you buy insurance on each other's life and so on. So that one, speak to a financial advisor if you happen to have investment properties or if you have a tenancy in common in your ownership of properties. Now, secondly, the second part that you are not able to put in the will would be your CPF nomination. Now, I can't stress this enough. CPF nomination makes things so simple, for your loved ones, quickens up the whole process of the money finding your family, right? Not sure if you have done, go on to cpf.gov.sg, log in to your dashboard, go under My CPF, go under Providing for your loved ones, and check. If you have already done, it should say completed. Well done. If you have not done your CPF nomination, may I recommend for you to do your CPF nomination as soon as possible, right? It is free, right? You don't have to think too much about it, right? Do one. It's a revocable nomination. You can revoke it anytime. You can do a new nomination, right? Just do it. And this is the link, right? This is the link to where you can make your CPF nomination. So by default, our CPF nomination comes in the cash nomination, right? Meaning to say, in the event of death, all the proceeds from your CPF will be paid out in cash. Now, today, if CPF board happens to have the bank account of your beneficiaries directly paid out to them, otherwise it will be done via the check, right? So that is cash nomination. Now, the second and third way, slightly less common, but still something that people may want to consider for various reasons. Number one, today, if they are afraid that their beneficiaries may not be able to handle large amounts of money, right? One time, you get 200,000, 300,000, you're afraid that your beneficiaries may squander the money. You can choose enhanced nomination scheme, whereby your CPF monies get distributed to your beneficiaries' CPF accounts. So that's one way. Now, the other way is Special Needs Savings Scheme, SNSS. Now, this is very specific. Now, more information is available on SNTC's website, Special Needs trust company's website, there's a whole list of what constitutes special needs. Now, this could be special needs family members whom you have as nominees. Now, instead of distributing in a lump sum, what this scheme does is that it disperses your CPF savings in the form of monthly payouts instead, right? So for enhanced nomination scheme and special needs savings scheme, these two you will need to do it through the CPF Service Center, right? The only nomination that you can do online, DIY, self-help, is the cash nomination. And I would like to highly encourage for all of you in my audience today, if you have not already made a CPF nomination, please go ahead and do so. If you have already made a nomination, do check. Feel free to update it, right? As your family situation changes, right? It's important to keep your nomination updated as well. Now, on CPF nomination, not everything is covered, right? There are areas that are not covered. For home protection scheme, is directly paid off to your creditor, be it the bank that is issuing the loan or HDB that is issuing the loan. CPF investments, once the money is taken out of your CPF, it forms part of your estate, right? So it is not included in your CPF nomination. If you have any money that you have invested via CPF investment scheme, please make a will, right? Please write a will. Otherwise, it will be distributed according to Intestate Succession Act. Now, lastly, this came up in the news today, I believe, right? Great Eastern, our dependence protection scheme insurer, they have been awarded another extension of 3 more years. So for those of us who have not already done our nominations, please do visit Great Eastern website, right? Just do the nomination, get a form accordingly, and just file the nomination accordingly, right? Free of charge. So please do that for your dependence protection scheme. So essentially that $70,000 of payouts for anyone who is under the age of 65. All right. Now, lastly, this topic of insurance, right, is very, I wouldn't say it's complicated, but it is important as well, right? Because when we buy insurance, we want to make sure that our loved ones are well taken care of. Now, long ago, when insurance, was still in the early days, right? Nominations can only be made to spouse and or children. Now, in this manner of nomination, a trust has been created. This is also known as a trust nomination. Now, what does a trust mean? A trust means essentially a trust is a tool that you park all your assets in and you give up the rights to this asset, right? So in this case, when we're talking about trust nomination for insurance, you essentially park the insurance in the trust, right? If you have done a nomination, and that trust now, the beneficiary of that trust would be your spouse and or children. Now, the reason why this is a pretty old way of nomination is because back then, right, there were, I'm talking about many, many years ago, like 60, 70 years ago, right? Many people, they may be self-employed individuals, right? Or they were not employees of companies at that time, right? And these people, their assets are all lumped up together, right? As your personal assets. Today, if you happen to become a bankrupt for whatever reason, and if you were to pass away as a bankrupt, then there is a problem, right? You are afraid that today, if you were to pass away as a bankrupt, your creditors will come and force your loved ones to liquidate insurance policies and liquidate whatever. So therefore, the purpose of trust nomination was formed, right? The purpose of trust nomination was to provide for that assurance for your loved ones in the event if someone passes away, in the event of bankruptcy, then their assets, their insurance policies will be protected from creditors. Now, today, nomination framework has been simplified, right? Under Section 49M, the new section ruling is Section 133. Today, you can nominate anyone, not just spouse, children. Today, you can nominate your siblings, your parents. You can even nominate a friend, or someone who is totally unrelated, right? And today, nominations can be revocable, right? You can also use a will if you want, right? But my recommendation when it comes to nominations, please keep it clean, right? What do I mean by that? Today, the best way for you to look at your insurance nominations would be do a nomination for every policy that you own. Now, don't try and rely, everything on the will, because today the will, you will need to have schedule of assets and so on. You need to make the will known to the insurer, right? So the will may not be the best tool. Nomination is the fit for purpose tool when it comes to distributing your insurance policy. So again, right, if you can't remember anything that I've shared throughout, just remember insurance policies, keep it clean, do a nomination for every insurance policy that you own. In that way, you are using the insurance company's forms, right? There is clarity, it is simple and easy for both the policyholders and also for your loved ones, right? So that's insurance nomination. Now, for those of you who have not written a will, I would like to invite all of you to um, start thinking about writing a will, right? And a lot of times the difficulty comes in when you're thinking about who to become, who should you make the guardians of your minor children. And a lot of times parents sit on this and they forget about it. Now, the difficulty is that today, if you do not do anything, if something happens to you when your children are still under the age of 21, that's the big problem. But if your if nothing happens when your children turn 21, then that's fine, right? But we don't want to hope for that to happen. So may I invite all of us in my audience today, if you have not written a will before, you might want to consider writing just a simple will to get started, and you can do so for free on the MoneyOwl website. So you can scan the QR code, right? And okay, you can scan the QR code and you'll be able to get started writing a will. Very simple. You just need 20 minutes. Instructions are there, right? And all you need to do is to follow that, right? So steps are there, but there is also this document known as the Schedule of Assets. Now, Schedule of Assets is not legally binding, right? Just like the Letter of Wishes or Letter of Intent, Schedule of Assets essentially is a list of all your assets, right? And you also want to include whatever liabilities that you have. Now, a simple will is good for most people. But today, if you have very specific bequests, for example, like I mentioned earlier, in the case of a property, you would like your beneficiaries to continue living in that property. And perhaps you want to put that in a clause very specifically, that property must not be sold. Today, if you have certain investments, for example, and you want the investment to be invested, to continue being invested, right? You might also want to put that in a clause accordingly, right? The investments should not be sold off upon my death, and so on and so forth. Now, a simple will not be able to make customizations like that and specific bequests. So a simple will, essentially, when you do that, everything is assumed to be sold off and distributed in cash. Okay, so there are limitations, and that is why it is free. It's a free service, but it is a good enough interim for most people, especially when it comes to nominating of guardians for your minor children. So please do check that out. Now, before I end off this evening's session, I also have a bit of sharing that I would like to do on lasting power of attorney, right? But before that, I also want to highlight it's not just lasting power of attorney. The whole process, the whole journey of planning starts with this umbrella term called advanced care planning. Now, where can you get more information? Agency for Integrated Care. And I have the link in the slides, right? Don't worry, you'll get a copy of the slides if you would like to refer to some of this information that I have in my sharing today. Now, that is a process. And what are the documents? The documents include your lasting power of attorney and Advanced Medical Directive. What are the differences? Advanced Medical Directive, I will explain in the next few slides. Lasting Power Attorney, LPA, I'll explain in the next few slides. For Advanced Medical Directive, essentially that is, put simply, it is the license to pull the plug, right? Today, if you are deemed as terminally ill or unconscious and you don't want to be kept alive, extraordinary life-sustaining support, then please do opt for that Advanced Medical Directive document, right? Each of these resources, I have all the necessary information, and I won't be able to go through in detail, but specifically, I want to touch on this important document called the Lasting Power Attorney, because today, we're not just worried, right? Today, in the event of a death, but also in the event of losing of my mental capacity. And what are examples of losing of mental capacity? Advanced dementia, for example, right? Today, if you are unable to take care of yourself, you need to appoint, right, donnees to help you with certain decisions. Now, two forms for you to consider in the lasting power of attorney. Again, most of us, we can make use of just the Form 1, which is a simple checkbox powers, right? Basic restrictions. Form 2, you need to go to a lawyer for them to clause it out accordingly, depending on what your requirements are. Most of us, 90%, I would say 95% of us, we can just make use of an LPA Form 1. Now, I also want to highlight that there is this group of people called professional donnees and deputies. Obviously, you'll need to pay them a fee for them to be nominated as donnees for you. Today, if you're in the event that you are worried, you don't want to put the burden on your loved ones, for example, you might want to consider there's a whole list of these professional deputies and donnees, and they are listed on the Ministry of Social and Family Affairs website, Office of the Public Guardian. Now, what are some of the powers that you can grant to your donnees? That include personal welfare and money affairs, right? Property and money, right? So anything to do with managing your bank accounts, household expenses, rental, sale, CPF, or day-to-day care, right? Should you be admitted into a nursing home? Who to take care of you? How should you go about your day-to-day living, healthcare decisions, social activities? So these are the broad areas that you would like to grant powers to your donnees. Who could be your donee? Very simple. Anyone who is 21 years old and of sound mind. Trustworthy, reliable, competent. There are 3 questions that you want to ask yourself when you decide who can be your donnees. Number 1, can you trust them? Can you trust them to make a decision for you in the best interest, in your best interest, right? Are you confident of their capabilities in helping you make those decisions, right? Do you think they are able to make those decisions on your behalf? Now, today, if you have a situation whereby you would like to appoint multiple donnees, bear in mind, are they talking to each other? Can they get along with each other as well? Now, so today you can choose just one single donee or you can choose multiple donnees. Both decisions are valid, right? So jointly and severally, both decisions are valid. And when any one of the donnees are unable to act, the joint appointment stops immediately, right? So that's something that you want to consider as well. Today, maybe if you feel that the burden on one family member is going to be too much, right? Maybe you want to split the responsibility between 2 donnees, right? So that's really up to you. How do you go about doing lasting power of attorney? Here is the link, right? Office of Public Guardian, step-by-step instruction. Number 1, decide who. Number 2, draft it online. Number 3, visit a certificate issuer. I'll have the relevant costs that I will share in the upcoming slide, and done. Very simple. Now, my 73-year-old mom, right, managed to do this all by herself, right, with just some simple guidance. So if she can do it, I believe all of you are able to do that as well. Not just for yourself, but maybe also for your elderly parents, like in my case, right? being the donee, being nominated as the donee to someone else as well, being aware of what are the duties that you need to undertake, right? So what is the cost? Currently for Form 1 for Singaporeans, no fees. The fees are waived. For Form 2, $100 for $100 for PRs, $250. For Form 1, $100 for PRs, $250 for foreigners, free for Singapore citizens, all the way to 31st March 2026. Form 2, because it's more complicated, there needs to be a fee of $200 to $300 depending on your citizenship. Now, that's the application fee payable to Office of Public Guardian. There is also another fee that is payable to the professionals, the certificate issuers that you visit. Now, my recommendation, go for the cheapest, right? Go for your GPs, your doctors. It can be anything between the cost of $25 all the way up to maybe $50 and so on, right? Obviously, today, if you were to go to lawyers, psychiatrists, you can, but those are a little bit more expensive. Now, all the costs are published on Office of Public Guardian website. Now, if you happen to have a need to use a Form 2, the lawyer will charge according to how many clauses you want to put in. So complexity of the case will decide how much you need to spend, all right? Now, lastly, I just want to also highlight there are tons of very good resources available in our estate planning journey. It doesn't end just by attending a 1 hour session today. I believe there are a lot of questions and I do see some of them in the chat. Now, I will be going through some of these questions that you have asked. So bear with me, right? I just want to share this very good resource, which is a government website, right? My Legacy. At Life SG, right? So My Legacy, there is this service called the My Legacy Vault. So essentially, it's a place where you can lodge information of your various wills, nomination, your will, your nomination, and so on, right? Important information that you want to share with the family. Now, just bear in mind that today, at this current moment, there is no such thing as a soft copy will yet, right? We also cannot electronically sign a will yet. I say yet because we don't know, right, how things are going to be. Is the law going to be updated in the future? I don't know. So let's keep an eye out for that. But for now, you can only put in information that's relevant to your wills, right? So have you written a will? Where have you kept the will? And so on. Who is the executor? And so on. Just the information. There is also another place called the Wills Registry, but that is a chargeable service. Okay, so that's putting all the information. So on top of that, on top of the vault, there is also multiple resources on how should you go about writing your will, lasting power of attorney, how should you go about doing that, what to do when death happens, how do you go about step by step, right? When death happens, if death happens overseas, and so on and so forth. So tons of resources available. Now, we have also come up with an estate planning ebook, right? And we recently just made some updates to our estate planning ebook. I welcome all of you to just scan the QR code, right, and download our estate planning ebook to read more in detail. If for whatever reason today, yeah, I do see there's tons of questions in the chat, right? If you're unable to get your questions answered, right? I hope this book will be able to provide some resources for you, or otherwise, feel free to join us on our Telegram community, right? Put your questions there and we'll try our best to answer some of these questions that we may have missed out in today's webinar session. Now, for a copy of the slides, please do consider joining us on our mailing list, and we'll be happy to share a copy of today's presentation with all of you for your reference, right? And with that, I have come to the end of this evening's webinar session, right? I do apologize today if we are unable to address some of your queries, right? But we'll try our best. Do join our Telegram channel or drop in a note on our website if you have any further questions that we are unable to answer today. Now, let me just take the next 1 or 2 minutes to go through some of these questions that you may have asked, right? Yeah, with that, for those of you who would like to take your leave, thank you very much for your attention this evening. And I hope you have a great evening ahead. I hope you would like to go ahead and consider some of these actions that I have shared over this past 1 hour session. And all the best to all of you, and I hope to see you in our next installment of webinars, right? And have a good evening. Okay.